Okay, you can see it. Okay, so what I would like to do and to present in the framework of this conference is taking the example of Belgium, which is the country on which we have been working in the framework on the ObsidianNet project, with a view to highlight, I would say, the challenges and the shortcomings in respect of the way the judicial criminal system handles or deals with defendants with psychosocial or intellectual disabilities, be there, I would say, suspects, accused, or even convicted and then imprisoned. This is why I will try to highlight, to exemplify with this presentation. I will start with a very brief overview of the, I would say, the generic Belgian legal framework as it relates to, I would say, disabilities and rights, if I may say so. As in most of, I would say, democratic and rule of law based countries, the Belgian constitution has a specific article, Article 10, which contains a general, I would say, general equality rule and a general prohibition of discrimination. Not a specific one, be it for people with a mental illness or a physical disability. Let me just say what the article states. All Belgians are equal before the law. And in addition to this, the Article 11, subsequent one, declares that the enjoyment of all rights and freedoms has to be assured to all Belgians without discrimination. Of course, Belgium has ratified the Convention on the Rights of Persons with Disabilities and its optional protocol. Um, we have already been discussing the content of this convention this morning, thanks to the brilliant intervention of Maria Musmuti. Um, Besides, I would say this generic equality rule enshrined in the Constitution, we should also mention a specific Anti-Discrimination Act, which had been further adapted also to the European initiatives on the same issues. And this act includes provisions on reasonable accommodations for persons with a specific disability or handicap. Although obviously most of, I would say, specific policies which have been implemented after or pursuant to this Anti-Discrimination Act relates to, I would say, work, social benefits or social protection, or in the field of education, not only employment. The Article 5, which defines the scope of this act, mentions inter alia the access to and the offering of public goods and services. So, which means obviously that it also covers the access to the justice system. Now, in respect of, I would say specifically judicial proceedings, we also have in Belgium several legislative provisions which seems to pay more attention to the rights of these vulnerable groups by allowing for special measures. But I would say that they are mostly limited to the provision of free legal aid. And that's all. And in addition to that, also special attention is being paid to the what I call the patient rights of people with mental illness when they are subjected to legal protective measures. But this is something I will talk about later on in my presentation. Now, let's talk a little bit about statistics, if I may say so. To be honest, I'm not a fanaticist or a fan of numbers and statistics. But anyway, I think that I believe that if you want to be able to address a social issue, you also need to be able to assess its scope, its dimension, and its specificities. When it comes to Belgium, what we have, I mean, despite the availability and collection of many health and healthcare data, there are so far no integrated or aggregated, they are not integrated or aggregated into a real, I would say, centralized health information center. I mean, the various actors involved in collecting these data, they vary from one database to another. Additional challenges include the lack of unique patient identification between all available databases, difficulty with the diagnosis and treatment data as far as validity is concerned. So no official centralized database on persons with disabilities in Belgium. This is due to what I just mentioned. So the discrepancies of criteria establishing the degrees of disabilities from one region to another. You know that in Belgium we have this very complex, I mean, state organization, and also because there was no national census carried out in this field. We have, I would say, surveys carried out by the Scientific Institute of Public Health in Belgium, but these surveys are neither recent and nor are they providing a clear picture on the number of persons affected by psychosocial or intellectual disabilities. Nevertheless, on the basis of, I would say, some estimates and an average prevalence, we can estimate that there are approximately 150,000 people with mental disabilities in Belgium, of which, according to the limited available data, around 50,000 people also suffer from psychiatric and other behavioral disorders. This lack of epidemiological data also applies to the justice system. Due to limited, non-systematic, and I would say inconsistent electronic data registration in the various existing databases. This means that if you want to try to have some picture, be it clear or not, of the number of, I would say, persons, suspects or accused, or even convicted, that have been so involved in the Belgian judicial system, it is absolutely difficult. I mean, it's even impossible. And the same applies, I would say, also to the prison administration. So they don't. I mean, Belgium currently does not use internationally standardized screening and assessment procedures in its penitentiary system that would more accurately, I would say, identify the prevalence of offenders with psychosocial and intellectual disabilities. Now, let's try to briefly explain, I would say, what the law says, I mean, and in particular, criminal law, in respect of the legal status of disabled offenders. disabled offenders, or I would say even defendants. I mean, not only people that would, I would say, enter the judicial system because they have committed an offense, but also because they have been victims of an offense. And actually, most of the existing literature and research in Belgium refers to the access to justice and a victims' rights approach. So very, very few, if not nothing, has been conducted in terms of studies, research, surveys, whatever, in respect of, I would say, suspects and accused. For instance, you have a lot of literature trying to highlight how the mental illness of a victim can be an aggravating factor for some offenses. So, which means if you have, if you are mentally disabled and you are a victim, and the judge has to pronounce a verdict in this case, the verdict will imply an aggravating factor because the victim was mentally disabled. Another, I would say, major topic which is present in Belgian research is the treatment of mentally ill offenders and the question of criminal liability. The Article 71 of the Belgian Penal Code, as in many others national penal codes, states that no crime shall have been committed where the accused or defendant was in a serious state of mental imbalance or debility, rendering them incapable of controlling their actions or were subject to an irresistible impulse. From the point of view of criminal law, people with mental disorders who make them unable to control their actions, even if they are the material authors of an offense, cannot be convicted and sentenced to a penalty. So this, of course, relates to the cause of criminal incapacity. Also, Article 71 of the Criminal Code allows the judge to dismiss the case or order an acquittal in this case. The law, we have another law, which dates back from 1964, which is the law on social protection and internment, and actually it is called the Act on Protection of Society Against Abnormal and Recidivist Offenders. This law allows judges to order the person to be interned if the mental state in which they were at the time of the crime was committed is still present at the time of the court investigation or judgment. This is this measure is called internment measure, and I would say the spirit or the philosophy which grounds this measure is that the offender, even if he's not deemed criminally responsible, is seen as a danger for society, but also as a person who needs treatment and care. So, stricto sensu, this internment measure should be defined as a safety measure rather than a punishment. I would also say that this law of 64 has then further be amended in 2014 and 2016 with provisions trying to, I would say, enhance or reinforce the rights of the internees. Also putting more, I would say, attention on the respect of human dignity, but also on the purpose of the internment measure as a transition for his or her reintegration into society. But anyway, having said that, the main rationale, I would say, and focus on this measure, still with the the law as amended in 2014 and 2016 is still, I would say, the traditional one as of 64. I mean, protecting society against mentally ill offenders who are considered a danger to society. So this is still the philosophy of the law, actually. And I also have to, I mean, I think it's also important to mention that the measure, so this measure, internment measure that may be ordered by investigating or court judges is pronounced for a relatively indeterminate period. It depends on the seriousness of the act committed, but the measure actually makes it possible to confine an individual for his entire lifetime if it is considered to still represent a danger for society. Just one thing I would like to mention in respect of the law as amended in 2016, because it is important. The law as amended, so in 2016, now says that persons can be subjected to an internment measure if their criminal offense harms the physical and psychological integrity of a third party, if they have a mental illness at the same time of the offense, and if there is a danger of committing new offenses. Consequently, only persons who have committed criminal offenses harming the physical or psychological integrity of a third party can be interned. This is important, and this is an important difference, because the previous law did not require that the crime of offenses committed be punishable by imprisonment. So as a result, persons with disabilities were detained for minor offenses, which would not have resulted in imprisonment had they acted as ordinary defendants. So I think this is something very important to highlight. Now let's come, I would say, to the various actors of the chain of the judicial system, if I may say so. Police, as in many other countries, can be considered as primary first-line respondents when it comes to handle with, I would say, suspects or accused with psychological or intellectual disabilities. They constitute, in a way, the first stage of the judicial process, in which suspects and accused with psychological and intellectual disabilities might be involved. Pursuant to the Belgian law, police services have among their tasks the supervision of mentally disordered persons who seriously endanger the health and safety, etc. This is the aspect I just mentioned before. They should also seize those who are reported to them as having escaped from the psychiatric ward where they were put under observation or placement in accordance with the law. Finally, the police services are also tasked to supervise the internees to whom the sentencing court is granting one of the methods of execution of the internment, including monitoring compliance with the conditions communicated to them for this purpose. This obviously, this is a broad range of possible interventions, and without saying, obviously, the possible intervention of intercepting or even having simply the first contact with a person in the street might be considered as a suspect of something that happened. And this is also, I would say, this can also be related to simple administrative checks in the street. So, I mean, the range of possible intervention or interaction, I would say, between police officers and the category of this vulnerable group is very broad. Now, obviously, according to the law, the police intervention must in all cases meet the principles of legality, subsidiarity, proportionality, and opportunity. So This means, on the one hand, that priority should be given to the least coercive and radical dialogue or interaction and intervention techniques. And on means that the modalities of intervention must be adapted both to the objective, the circumstances of that intervention, which will depend on the behavior and state of vulnerability of the person to whom the police intervention is taking place. The respect of the aforementioned principles, so these conditions, the conditions the legality of police intervention. So this is very important. And to this purpose, obviously, police officers are trained, I would say. They receive in Belgium basic training, which includes a module dedicated to intervention in situations involving mentally ill persons, or I would say people with psychosocial or intellectual disabilities. However, despite this basic training and even specific advanced trainings that they might take voluntarily and individually, despite, I would say, all these initiatives, associations in Belgium representing people with disabilities and promoting respect of their rights consider that they are not sufficient or sufficiently implemented to ensure appropriate communication and interaction between police officers and people with psychosocial or intellectual disabilities. I was mentioning, just before, the case of identity or administrative or judicial, administrative checks. It is not common, even in Belgium, like in a lot of other places in the world, not uncommon for a person with a disability to be deemed to be a delinquent due to a lack of proper understanding of its condition. For example, people are sometimes arrested on the street, not on the basis of an offense they have committed, but on the basis of a behavior they display, or simply because they did not have the capacity to express oneself or to make oneself understood. So I will, I don't know if I still have time. Okay.
Go ahead.
Yeah. I would say that police authorities are aware of this knowledge gap, as well as its potential negative impact, considering also the increase in the number of cases requiring police intervention with respect to persons in a vulnerable psychological or mental state. Only to mention Brussels, for example, we can see that in between 2010 and 2018, the number of police intervention in this case of situation has doubled. In 2010, for example, there were 329 intervention aimed at, but this is specific, aimed at, I would say, intercepting vulnerable people for an admission in a hospital. And in 2018, the same type of intervention amounted to 687. I would add to this, and just to conclude this section, that shockwaves provoked by extreme dramatic cases with a wide media coverage also reminds in a dramatic manner the existing shortcomings in terms of appropriate preparation and knowledge and identification by police officers when it comes to handle with crisis intervention. I will not enter into the details of this case, but all of you surely knows this was recently highlighted again in Belgium after the release of video evidence of a heavy-handed police treatment of a Slovak national Joseph Chovanec in 2018, which happened in the airport of Charleroi. Now, I would say another important actor in this chain of the judicial system is the lawyer. I mean, is the legal assistance. As previously said, most of the existing current legislative safeguards with a mental disability are related to their entitlement to free legal aid. However, neither the identification by the police, prosecuting authorities, or the courts, or the identification by a psychiatrist of a severe mental disorder is made with the aim of granting the defendant additional extra-legal assistance in order to be able to participate in the proceedings properly. The regulation do not mention the possibility of instigating extra-legal procedural protection involving, for example, a relative, a social worker, or a healthcare professional in order to safeguard the fairness of the proceedings. Similarly, there are no specific provision in order to ensure appropriate access and comprehension, I would say, so access to documents for persons with cognitive disabilities. Therefore, the person in question has no other choice than to rely solely on their lawyer. And in this regard, and this is something that was also highlighted in the various documents produced in the framework of this subsidiary project, communication between the lawyer and the client is extremely important. If some lawyers are specialized in dealing with cases involving defendants with psychosocial or intellectual disabilities, there is no currently in Belgium procedural guarantee that this latter would be represented by such specialists. So this leads me to say that current measures or provisions aimed at the identification of mentally disordered defendants do not have in Belgium a true and proper fair trial rights finality. Very briefly on this, I won't extend more on this because I already talked about it before, but this lack of understanding of disabilities among, I would say, staff is nowhere as dramatic as in the prison system. While the principle of reasonable accommodation has been enshrined in law, there are no measures expressly intended for persons with disabilities in the prison regulations. Certain actors within the prison system do promote, I would say, the natural practice of making such accommodations, particularly in the case of staff working within prison psychiatric units. However, such individual way of addressing special needs of disabled inmates is not sufficient nor appropriate. So as a recommendation, I would say that the Belgian penitentiary administration should integrate the concept of reasonable accommodations organically within its policy, staff training, and also infrastructure design. Now, before reaching my conclusion, I would just like trying to express how for me, how I see, I would say, the originality of the Obsidianate project in which we have all been involved over these two last years. I think that the approach driving this project is not only forward thinking, but also realistic. It is clearly based on a rights-based approach so ensuring the principle of equality, ensuring the same and full enjoyment of rights for people for suspects and accused with psychological, psychosocial, and intellectual disabilities, such as any other member of society, but without, I would say, undermining also the safety and security dimensions which law enforcement professionals have also to take into account. And at the end, this balance, for me, is also, in a way, the quintessence of the rule of law. What also Obsidian Project has demonstrated, but not only Obsidian Project, also other projects, that police officers are primary and first line respondents. And in this respect, the interaction they need to have with suspects and accused with social, psychosocial, or intellectual disabilities should be a kind of balance between the model of authority they represent and the full respect of the person's rights. So this means require training and knowledge to ensure appropriate measures safeguarding their own safety, but also the defendants and others' ones. And I would say also that this project was, in a way, based on a knowing the limits motto, because the purpose, and it was clearly said in all the documents we have produced, is not for police officers, for example, to be able to deliver a liable psychiatric or psychological diagnosis or strive to be a substitute to medical expertise. This is absolutely not the purpose. But what is important is ensuring a first line proper communication and identification, and then rely on other adequate supporting actors. And of course, the manual produced also and other documents highlights the key role of the lawyer, of legal aid, in ensuring abidance of judicial authorities to the respect of the defendant's cognition and comprehension of his rights. So at the end, I would say, if I may summarize, the aim also of this Obsidian project, or the spirit, is to ensure a fair application, implementation of criminal judicial procedures, a proper and adequate identification and communication of and with the defendant means, and notably and crucially, let me highlight it, by avoiding potential false declarations. So this means, above all, ensuring justice takes its due course, safeguarding the rights of a defendant, but also trying to ensure the credibility of the judicial procedure.